Jefferson County Court at Law number 2 is in session. The court is in session in cause number 25 CCCR 1356. Case is style of State of Texas versus Gavin Shashawn. Let the record reflect that Mr. Shashawn is present in court with his attorney, Attorney John Macy. State is present in court with State Assistant District Attorney, Attorney Cornelius Williams.
Good morning, Your Honor.
Good morning. And I have before me a motion to modify bond conditions that was filed by Mr. Macy on behalf of his client, Gavin Shashawn. And Mr. Macy, would you like to go forward on your motion?
Yes, Your Honor.
Okay.
Thank you.
And you're gonna call your first witness?
I am, I call Gavin Shashawn.
Okay, now you're gonna have Mr. Shashawn testify in the witness stand? Yes. Won't you come forward, Mr. Shashawn? Okay, now, Mr. Shashawn, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Shashawn, you may put your hand down. Mr. Shashawn, you can take the witness stand. Miss.
Yes. Okay.
Okay, Mr. Macy,
Thank you, Your Honor.
you may proceed.
Gavin, did you state your name for the record?
Gavin Shashawn.
You have to speak up, sir.
Gavin Shashawn, G-A-V-I, C-H-A-I-D.
Yeah, best you can, try to keep your voice up so everybody in here can hear you, okay? You, were accused, of harassing your brother Jaden on or about May 22nd, 2025, right?
Sorry.
Okay, and you entered into an agreement with the state of Texas, with the district attorney's office to enter into the BIP program, right?
So,
And you signed that agreement last Thursday. Is that right?
sorry.
And in the meantime, you are currently ordered to wear an ankle monitor, GPS monitor, correct?
Yes, sir.
And that monitor, I put in my motion that the monitor costs $300 a month, but it actually, I was told today, it's actually costing y'all $225 a month, is that right?
So,
Can you afford that?
oh, sorry.
Okay. How old are you?
18.
Yeah, 18. You just graduated?
Yes, sir.
And what day did you just graduate?
May 19.
Okay. And you're currently working at Wingstop?
Yes, sir.
Is that full-time or part-time or
No.
just whenever they give you hours?
Full time.
Okay. You're ordered not to have any contact with your brother Jaden. Are you complying with that order? Okay. If the judge chooses to allow you to have that ankle monitor removed, you'll continue to comply with that order of not having no contact with Jaden. Is that right? Yeah. And you already have that condition as part of the order that you agreed to in your BIP program, right?
Yes, sir.
So BIP does, the BIP program agreement that you entered into says that you will continue to have no contact with Jake.
Yes, sir.
Um, and so you're asking the court to allow you to be able to have that ankle monitor removed so that it can save you the money that you can't afford to be paying them, in this case, right?
Yes, sir.
Okay. I'll pass with you.
Good morning, Mrs. Shoshana.
One,
Mrs. Shoshana, where do you live?
730 Schoolwood Street.
What he said.
1130 Skipwith?
Sir.
Your mom name is Megan Shoshana, right?
Yes, sir.
She lives over there, 1130 Skipwith, right?
Yes, sir.
Jake lives over there, 1130 Skipwith.
No, sir.
When did he move?
More than this and a half.
And we're talking about where does he live?
Talk to him.
You don't know, you don't talk to him. So
I have no
it's,
contact with him.
yeah, okay, you have no contact with him. You don't know where he lives. Your mama speak to your other son?
Does she speak with him?
Yes.
I wouldn't know.
Or you would know if your mama speak to her other children?
No. Not him specifically, but my other brother is. Not him specifically, though.
What hours do you work?
So I would do I work
Yes.
5 to 10. About 5 to 11.
How long you been working there?
About 3 months.
You see, you agree.
I'm sorry, which one? This one?
You do understand when you signed your BIP agreement that you cannot work past 10 PM. Do you see that I'm sorry, you say you graduated, right? You read okay? Excuse me, got to answer for the
Yes,
rest.
sir.
You see that you cannot be out after 10 PM?
Yeah.
You see that you cannot, you have to be home by 10 PM, correct? And you cannot leave until 6 AM, not before 6 AM. Do you see that? So you're already violating your conditions when you just signed last week by working, right?
You said what?
Okay, I'll ask you-
He's mischaracterizing the law. My understanding is that he has a curfew that he has to comply with unless he's working. And as long as they know he's working during those hours, then they can allow him to do that. He just can't willy-nilly violate the curfew.
Your Honor, you can take judicial notice of the order if it's already within the court. It
Well-
does not say unless he's working. That's not anywhere in the curfew.
Okay, well, I mean, that's a contract between him and the district attorney's office. It's not a bond condition.
How can let me put it like this, absent a ankle monitor, how can the court know where you are at all times?
By keeping in charge.
Excuse me?
Keeping in charge. I come off and keep in charge, right?
How much do you make an hour?
So how much do I make an hour?
Yeah.
10 hours.
I'm sorry,
10.
about how many days you work a week?
I'd say 5.
Okay. So let's just assume you work from 5 to 10, okay? That's 5 hours a day. That's 5 to 10, or 5 days a week. 5 hours times 10. That's $50 a day times 5. That's $250 a week. That's $1,000 a month. You live with your mom, correct?
Yes, sir.
You make $1,000 a month. What are your expenses?
What's my expenses?
Yes, sir.
I don't have any right now.
No further, no further, let me. What you freely admitted to, although you're on the, batteries intervention program, you're within that program. You have to make admissions in order to get into the program, correct?
Yes, sir.
Isn't it
Yes,
true
sir.
that isn't it true, although you just told the court you don't know where your brother is, you had threatened to have, because you didn't have any money, and because your mom wouldn't pay for your phone bill, you threatened to have your brother shot with a 7.62, correct? That's the
Incorrect.
threat. That's not the threat. What did you admit to in a terroristic threat?
Where
sir?
did the phone bill come from? Wasn't none about no phone bill.
You did not threaten to have your brother shot with a
Yeah,
7.62 and get the
that's
money.
correct. That's correct. But I'm saying the other stuff, the phone bill don't got nothing to do with that. What are you talking about?
Okay, so you just threatened to have your brother shot with a 7.62.
That's correct. That's what it's all about. Him being threatened to be shot. That's me being in court is about.
Miss Mosby.
I'm gonna pass with this judge.
Okay, Mr. Mason. You have any other questions? Or may this witness step down?
No, I don't have any.
Okay, you may step down, Mr. Shoshone. Okay, you have any other witnesses?
What to call his mother?
Okay. Ma'am, would you please come forward? Ma'am, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand down. You can take a seat in the witness stand, and you can adjust the microphone and the chair if you need to.
Good morning.
Good morning,
Could you state your name for the record?
Megan Shelton.
You're Gavin's mother?
Yes, sir.
Are you Jaden's mother?
Yes, sir.
Um. Does Gavin live with you?
Yes, sir.
So you see, Gavin on a daily basis?
Yes, sir.
Does he have any contact with Jaden?
No, sir.
And you know the conditions of his, BIP program?
Yes, sir.
And so you try to help make sure he complies with that
Yes, sir.
because of the ramifications of what happens if he successfully completes his program, right?
Yes, sir.
And also the ramifications of what happens to him if he gets kicked out.
Correct. Yes, sir.
And are you in contact with Jaden?
Yes, sir.
Do you know where he lives?
Yes, sir.
But you may, is it necessary that Gavin know where he lives?
No, sir.
Does I'll counsel this judge.
Mr. Williams, you have any questions?
Briefly, Your Honor. Mr. Shoshone, why did Jaden have to move out after Gavin threatened him?
Jaden is older. I'm sorry.
Go
But
ahead.
Jaden is older. He had a job and he still has a job. So he had to move out.
I don't have any other questions.
Okay. May. You may this witness step down?
Yes, Your Honor.
Okay, you may step down.
Uh,
You have any other witnesses?
No further witness.
State, you have any?
Oh, no, sir, Judge.
Okay, any argument? Mr. Macy?
Your Honor, I just assert, Gavin is in the position now of being supervised through the BIP program. And it's not necessary, in our opinion, to have him continue to wear the GPS monitor. They already have procedures and processes to make sure that he complies. And he's complying, and he's going to continue to comply. And having that ankle monitor is basically taking about 25% of his income. Additionally, he has no control over his hours. So he could be cut back or not. Right now, he makes approximately $1,000 a month. That's still far less than, even if he lives with his mother, the income that he would make and spend would benefit the family unit as a whole. And we just ask that, I just think it's not necessary, considering what happened so far in the program, for him to continue to have to incur that expense. And we're asking the court to allow him to have that ankle monitor removed so that they can save that money, pending the remainder of the time he's going to be in the BIP program. And that's all I have to say, Judge.
Okay, Mr. Williams?
Your Honor, the state most vociferously opposes counsel's motion to remove the ankle monitor. You heard testimony from Mr. Shashan himself that he makes about $1,000 a month from his testimony. Judge, you also heard he had no expenses. The impetus of this case, and he corrected me when it was about a phone, Judge. He threatened to shoot his brother, have him shot with a 7.62 and take his money. Yep, that's what I did in a terroristic threat. As this court has just, the contract is between the defendant and the district attorney's office, but this court has bond conditions, Judge, which in fact are set to where he can be monitored. I submit to this court that if he doesn't come in at 12 or if he doesn't come in at 4, there's no way this court would even know that. Therefore, we respectfully request that the monitor remains in place during the pendency of this case. And there's been no showing that it's a hardship. He took the stand. He did not say, well, I give my mom money. I try to help my mom out with the bills. No, he didn't say that. I have no expenses. So he's getting $1,000 a month, no expenses. And I submit to this court, you noticed the trier in this particular matter, again, of the fact you get to notice the demeanor of the individuals who appear before you. Not only the mumbling or disrespect, I will submit to this court the lack of respect for the court for these proceedings. There's no way that we can know he will abide by the court's orders unless we have the most strenuous things in effect, and we think that the ankle monitor is warranted. Thank you,
Okay.
Judge.
Okay, at this time, the motion to modify is gonna be denied. Okay? That's the ruling of the court. All right. Okay, Mr. Macy, y'all excuse.
I'm sorry, what?
You all excuse. Okay. That door is locked. You gotta go through the other door. We have to move it. Okay, excuse me. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at London 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at London 2. This morning, you have been asked to come to court for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. 1 minute. And your felony cases are normally referred to as your most serious type of criminal offense, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail. And a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those punishment because, as I mentioned to you earlier, your offense is a misdemeanor case. So misdemeanors are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, if a person is convicted of a class C misdemeanor, the range of punishment is fine only, and the fine cannot be above or cannot exceed $500. Now, if the person failed to pay the fine, or if the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a habeas pro fine. What that means is it's a warrant for the person's arrest, for them to pay the fine or to sit the fine out in jail. And if they sit the fine out in jail, they will be credited at $100 per day for every day that they spend in jail, and that $100 will go toward the payment of the fine and court costs. Now, the next highest misdemeanor is a class B misdemeanor. The class B misdemeanor, the range of punishment is a minimum of 0 days to a maximum of 180 days in the county jail, or they can be given a fine that does not exceed $2,000, or they can be given both such jail time and a fine. Now, the highest misdemeanor is a class A misdemeanor. With the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is year in the county jail, or they could be given a fine that does not exceed $4,000, or they could be given both such jail time and the fine. Now, as a defendant, well, also you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation, and the other type of probation is called adjudicated probation. And the difference between the 2 is as follows. With the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete that probation, the case will be dismissed, and you may qualify for what is called a non-disclosure. Non-disclosure means that your record will be sealed to the general public. That is, the general public cannot have access to your criminal record if you have a non-disclosure. Now, the operative word is general public. There are certain governmental agencies that can have access, like the police department. But most of the public is general public, so most of the public cannot have access to it. So, for example, let's say you apply to a job at ExxonMobil. Let's say you have a non-disclosure. ExxonMobil does a criminal background check. Guess what? It's sealed to them. They can't see what's in it. Okay, they can't find out that you had deferred adjudication for this particular offense. All right. Now, The next type of probation is called adjudicated probation. Now, with adjudicated probation, it does result in a conviction and record. However, there is something that is called judicial clemency. It's similar to a pardon, whereby the judge can set your conviction aside. You will no longer have that conviction. Now, if you get a subsequent conviction, subsequent means like if you get another conviction later on, then the case that you receive judicial clemency on can be resurrected. It can be revived. It can be brought back up, and it could be used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can suspend or revoke that license. Okay, now you can enter one of three types of pleas. Okay, a person gonna enter a plea of not guilty. You enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you've been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting those charges. Okay, now everyone here for arraignment, you should have a clipboard. Who does not have a clipboard? Make sure you have a clipboard. I'm going to go over that paperwork that's on the clipboard with you. Now, the first document, after the document that is a half page, the first document should look like this. And it is titled Judge's Explanation of Rights to Defendants Without Attorney. I'm going to go over this document and I will constantly refer back and forth to this document. The document says that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first sentence under number three states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard. And it looks like this. It's titled Jefferson County Affidavit of Indigence, or maybe just Affidavit of Indigence. For those individuals who will be applying for a court-appointed attorney, you would have to fill out this form. Now, if you're not applying for a court-appointed attorney, you don't have to worry about signing. You don't have to worry about what I'm getting ready to say about this. So for those individuals who will be applying for a court-appointed attorney, you would have to fill out this first page. Okay, so fill out the first page. And then we go to the second page. And on the second page at the top is titled, it states Defendant's Oath. You have to fill out just this top portion right here. And then you go to the middle portion where it says unsworn declaration by defendant, and then you stop. Okay, now going back to that first form, judge's explanation. Now we're going to give you time to fill out the paperwork. You don't have to fill it out right now. Now going back to this first document, there will be some people who would like to, there may be some people who would like to represent themselves. That is, you have a right to represent yourself. If you represent yourself, you'll be acting as your own attorney. And just like an attorney would have an opportunity to talk to the prosecutor or the assistant district attorney to see if you can work out something on your case, we call that a settlement, or it's commonly referred to as a plea bargaining agreement, you would have the same opportunity as well. You would have an opportunity to talk to the prosecutor. We have one prosecutor in court today, and that is Attorney Cornelius Williams. And you would have an opportunity to talk to prosecutor if you're representing yourself. Now, Before you can talk to the prosecutor, this one sentence paragraph, the third one sentence paragraph says that you may not speak to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. The written waiver for those individuals who will be representing themselves is also on the clipboard. It is titled, first of all, it looks like this is titled waiver of counsel for purposes of entering a guilty plea or proceeding the trial. This is only for individuals who will be representing themselves. You would have to read this entire document and then sign your name and date. Now, going back to this first form for individuals who will be representing yourself, there's a paragraph down here. It's in block form. And it states, be aware that the advantages and disadvantages of self-representation, waiving your right to an attorney and representing yourself, may result in the worst outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of firearms, housing benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, this last one sentence paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, what that means is this here. Let's say you represent yourself. And let's say you would like to see if you can work out a plea board. And let's say you want to see if you can get, let's say, unadjudicated probation. And let's say you talk to the prosecutor and the prosecutor say, well, I'm not gonna offer that, I'm gonna offer a fine. And you say, well, I don't want a fine, I want unadjudicated probation. So, judge, I changed my mind. I wanna hire a lawyer, I wanna hire an attorney, or I want to see if I qualify for a court-appointed attorney. Okay, you can do that. Okay, now at the bottom of this document, everybody that's here is going to make a choice. It says defendant's choice, marking issues to only one choice. Okay. If you would like to represent if you would like to hire an attorney to represent you, you will place your initials on the first line to the left at the bottom of this document. And then you'll sign and date today's date. And this is the only form that you would have to sign. If you would like to, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. And then you will stop. This is the only form that you would have to sign. If you would like to see if you qualify for court-appointed attorney, then you'll place your initials on the third line to the left. And then you'll fill out the first page of this document that is titled Jefferson County Affidavit of Interest or Affidavit of Interest. And you'll go to the second page, you'll fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant. And then you'll stop. If you've already been appointed court-appointed attorney, you'll place your initials on the fourth line to the left, the name of the attorney on the line to the right. You'll sign where it says defendant and date today's date, which is June the 9th, and then you'll stop. Now, if you would like to represent yourself, then you'll sign your name where you place your initials on the fifth line to the left at the bottom of this document. You'll sign where it says defendant. You'll place today's date, which is June 9th, and then you'll sign this next document that's titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. You'll sign it, read and sign this document, and then you'll stop. Okay. Do we have any questions before we move on? Anybody have any questions? Okay, no questions? All right. Now we're gonna give you time to fill out the paperwork. The next thing I need to talk about is your right to have a trial. You have a right to have a trial by jury when a gentleman is sitting in the jury box. We call that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to the evidence that is being presented by the state. They will be listen to the evidence that's presented by the defense. They will listen to the arguments of the state and the defense. And then they will go back into the jury room in the back and they will deliberate. And then they will decide whether to find you not guilty or guilty. Now, you can waive your right to have a jury trial. That means you can give up your right to have a jury trial. If you give up your right to have a jury trial, you will not be having a jury trial. You still can have a trial. You can have a trial without a jury. We call that a bench trial. That is a trial by judge. The reason why they call it a bench trial is because the judge sits on the bench. And so you will, the judge will be the judge and the jury in the case. The judge will listen to evidence that's presented by the state and the defense, listen to the arguments of the state and the defense. Then the judge will apply the facts of the law and decide to find you not guilty or guilty. Now, if you decide to enter a plea of guilty and no contest, then obviously, one, you or your attorney will see if y'all can work out an agreement with the state to have settle your case. We call that a plea bargain agreement. And if you come to an agreement, we call it an agreed plea bargain agreement. Then it goes before the judge. And the judge can do one of two things. The judge can accept or reject the agreement. Now, if the judge rejects the agreement, then you can take your plea back. In essence, you can say, well, judge, the state and I have agreed to say probation. And the judge, you rejected it, so I take my plea back. You can do that. If the judge does not follow the agreed punishment recommendation or the agreement that you made with the state. Now, if the judge does follow the plea bargain agreement, then if you decide within 30 days that you would like to appeal your case because you think that you may have been wrongfully convicted or the court committed an error by convicting you, then you have to get permission from the judge to appeal your case. And if the judge gives you permission, and then your case will leave this court and go upstairs to the 9th Court of Appeals where there are 5 justices up there, 5 judges. They will review your case. Excuse me, there's 4 judges up there. They will review your case and they will decide whether to accept, to grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, or they can send the case back down to this court and all this court to give you a whole trial. If they deny your appeal, then you can appeal it to a higher court than the 9th Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals, and they are located in Austin, Texas. Now, you have to file what we call a pro se petition for discretionary review. That means that pro se, you by yourself, you don't have an attorney representing you. You're petitioning or you're asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted or whether or not this court committed an error by convicting you. They can do one of two things. They can accept they can grant or deny your petition. If they grant your petition, then they can simply find you not guilty. Or they can send the case back to the 9th Court of Appeals with orders, or they can send it back down here with orders. Now, if they deny your petition at that time, then your conviction will stand. Now, the other right that you have a right to have witnesses to come to court. That microphone in front of that chair, we call that the witness stand. And what witnesses do, they can testify for you or against you. If you're representing yourself, you can ask some questions. Or if you have a lawyer, your lawyer can ask some questions. We call that either direct examination or cross-examination. Now, You also have a right to give up your right to call witnesses, which means that you can waive your right to call witnesses. What that means is you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. So now, you also have what is called a Fifth Amendment right against self-incrimination. I'll explain it to you. Fifth Amendment of the United States Constitution gives us a right to remain silent. In essence, we have a right not to testify against ourselves in our trial. That simply means that the state, the government, the district attorney's office cannot force you to take the witness stand if you exercise or if you invoke your Fifth Amendment right against self-incrimination. Now, I tell people this, that, you know, a lot of times we watch television, we see a television on, go up to the witness stand and ask the witness a question, the witness say, I'll take you to figure. And what that means, I'm not testifying, I'm not saying that. And you know what? It makes sense for us to have that right. Why? Because the state of Texas, the government has the burden of proof. That is, they have to prove beyond a reasonable doubt that you committed the offense. You don't have to prove that you committed the offense. Okay? That's what they have to do. That's their burden. That's not your burden to say, I did it. You know, you don't have to do it. And so, if you exercise your Fifth Amendment right against self-incrimination, that simply means that you have a right to remain silent. Okay, now, everyone that's here, oh, well, the next right that you have a right to have discovery. And what discovery is, you have a right to see what's in the state's file. Okay, you have a right to see that, have access to the evidence. You have a right to see your statements, witness statements, police reports, lab reports. You have a right to listen to audio recordings, see video recordings, see photos, see documents, have access to any instruments. You have a right to have a right to have access to the evidence that the state has and will be using against you. Now, you can waive or give up your right. Now, if you waive or give up your right to discovery, that means that you will not be having access to the evidence. Now, everyone that's here today, you have charges filed on you, you've been arrested, you're placed in the county jail, you bonded out of jail, you're out of jail on a cash bond, which means that you paid the full amount of the bond to get out. You're out of jail on a surety bond, which means you pay the bond, but a percentage of the bond to get out of jail. Or you're out of jail on a personal recognizance bond or a PR bond, which means that you did not have to pay any money to get out of jail. You was just released under your own personal recognizance. I say that to say this. Every day that you spent in jail, it can be used as credit towards your punishment. So for example, the operative word is every day. So let's say last night at 11:59, you booked in jail. And let's say 2 minutes later, 12:01, you booked out of jail. Guess what? That's 2 days. Why is it 2 days? Because yesterday was Monday and the day Tuesday, 2 different days. So you don't have to be there 48 hours. You got 2 different days. All right. And so that jail time can be used towards your punishment. So for example, let's say you spend 5 days in jail. Let's say the state is offering you 5 days in jail. Guess what? You don't have to spend no more time in jail. You don't have to go back to jail. Why? Because the 5 days that you spent in jail, you already served, so you will get credit for time served. Now, if they offer 7 days in jail, you spent 5 days, that means you only have to serve 2. Because you already got credit for 5, you're gonna subtract 5 from 7, and that leaves 2. Now, every day that you spent in jail can also be used as credit towards your fine and court costs. So for every 1 day that you spend in jail, you receive $100 credit toward your fine and court costs. So if you spend 5 days in jail, that's $500 credit. That can be used towards your fine and court costs. So if the state is offering you fine and court costs of $500, guess what? You don't have to pay anything. Why? Because the time that you spent in jail has already paid off. Therefore, it'd be tax and retirement. Now, if they're offering fine and court costs of $700, you pay 5 days in jail, that's $500. You're gonna take from the $700, that leaves $200 left. Now, you'll be required to pay the $200 on the day that you take care of your case. If you cannot pay it, No problem. Why? Because we could put you on what is called a payment plan. And so you can pay it off in small monthly installments. But let's say you don't have the income to pay off a payment plan. No problem. Why? Because we can convert your fine and court costs to community service. And for every 1 hour community service that you perform at a nonprofit organization, $12.50 per hour will be credited toward your fine and court costs. So in our scenario, if you work 8 hours, 1 day, that's $100. So in our scenario, if you work 2 8-hour days, guess what? That's $200. You can pay it off and that's it. All right. Now, Jefferson County has a program for people who have not had cases filed on before. And the program is called pretrial diversion. And what they'll dismiss, if you begin in the program, they'll dismiss your case. And guess what? You can get it wiped off your record. We call it an expunction. Okay? Now, in order to qualify for the program, 3 things has to happen. 1, it has to be the first time getting 1 or more cases. 2, you have to have a lawyer to assist you with the application process. The lawyer can be appointed or hired by you. And 3, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. If those 3 things happen, then you can qualify for that program. And as you complete the program, you can get it wiped off your record. Okay? The case will be dismissed and you get it wiped off your record. Okay, now if you are a veteran of any one of the branches of the United States military, the district attorney's office also has another program that is called pretrial diversion. And with the pretrial diversion program, they have BIP, Battles Intervention Program, they have anger management. So for example, all of those programs, you get into the program, they will dismiss your case. That's also part of the pretrial diversion program. Now, the other thing is, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that's called Veterans Court. And with the Veterans Court, they will get into the program, you complete the program, they will dismiss your case, and you can get that also wiped off your record. All right, now this court. County Court, law number 2 of Jefferson County, Texas has a program that God made me to start within the first 100 days of taking office in March of 2017. The program is called the CSI program. CSI is an acronym, CSI, that stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. Recidivism is a word that means people commit crimes over and over. They continue to do it. They call it recidivism. And so with that program, the program is designed to address the issue of recidivism. And the way we do it, we have partnerships with agencies in our community. And one of the agencies that we have a partnership with is Spindletop Center. We have some folks from Spindletop Center here. They're gonna come here in a little bit and tell you a little bit more about the program that they have to offer. But basically, Spindletop, what they can do today, they can have a private interview, either in our jury room at their facility by telephone or by text, whichever is convenient for the person that has mental issue that needs to be dealt with. They can do an assessment. An assessment is to determine what the mental health issue is, and they can develop a treatment plan for either outpatient and inpatient treatment. Now, with Spindletop, they have the expertise. They have the doctors, they have the counselors, they have mental health officers, and other individuals who are there who have the expertise to address mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You could really suffer from depression or anxiety or any other host of mental illnesses, and they have the expertise to address your mental health issues. Now, if you have issues with drugs and alcohol, well, Spindletop has a program that is called ATAR, ATAR, ATAR. It stands for addiction, treatment, and recovery. And also, we have a partnership with our local drug and alcohol council that has a program that is called OSAR. OSAR is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery program. And they have, basically what they would do screening, which is an interview. They would do an assessment to determine what your drug and alcohol issues are. And they would develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, they will assist you at getting a job in the areas that you're trained in. Now, if you have not graduated from high school, or if you do not have a GED, a graduate equivalency diploma, well, CICE as well as Spinotop, both of those programs have a GED program. And you can get your graduate equivalency diploma. Now, all these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this quote, we don't just give time. We take out time. That is, we do not just arrest the problem, we address the problem. And we believe that to address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. So I like to say that when you come to county court at law number 2 in Jefferson County, Texas, we don't just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned, just let us know, and we can direct you to the people that you need to talk to get on the road to living your best life. Now, as I mentioned to you earlier, we have some folks from Spinotop. They're going to come and talk to you a little bit, and give you a little bit more information on Spinotop. We have Tanya, we have Deputy Powell, and they're gonna let you know a little bit more about the Spinotop program. You're welcome.
How you doing today? Very good. All right. You should see this little form. Nothing here. Hey, thank you. Look, this has nothing to do with this form. This doesn't have anything to do with the case. All right. Miss Tanya, she's gonna go with a document with me. They're gonna go over some services. What I'm talking about. I've been with Jefferson County for 25 years. We started this program about 10 years ago, where we team up with Spinotop for Jesse and train and mental health license. That's my part. Have every day we respond to fire skills and all that. So the plan was to, that long ago, 10 years ago, was to team up and respond to crisis out in the community. I think it's worked out very well. I do believe so. That is riding with a professional shows that we can talk about how to actually respond to people in crisis, people with some abuse problems, like that's just putting hands on people in home after call, just trying to get the approach. So that's how we got this thing. Time you can go over the paperwork, and don't be afraid to sign it. Don't be afraid to fill it out. There's no judgment. You're protected under here, so I'm around the couch. Keep your mind open for you might be something out of it.
Everyone you guys, no more for the As you said, I'm Tanya, I'm a mental health professional. With the program, we have access to mental health, substance use, as well as military. With the things that we are able to do, we can come up to your home and speak with you guys. We can speak with you guys here in the courtroom if you would like to get more information. When we say mental health, it's not just, most people think, okay, this is something special, you know, I don't have the right things going on in my life or education wise. It's more than that. And that information, like I said, we guys can talk to you here. I know most people these days are tech savvy, so I will do text message as well as email. With the services, you don't have to actually start speaking today, but we can help get you set up as far as an appointment with a therapist or a counselor. We also have pharmacists on site as well. With the substance abuse, there are classes available on site at Spindle Top, like Deputy Holmes and Judge Deputy Holmes. Deputy Powell, y'all, I'm here too much, and Judge Holmes, both, it's not a requirement, but we would like to help if you need. If you have any questions, you guys can ask me now, or if you're aware that you can write down your paper, and we'll reach out.
If you come to your house, I'm gonna be in a black, she gonna be stepping out with me, some other, don't be trying to run high.
He will have on his vest, it's where.
Pardon for that.
Not the jump out boys.
Okay, it's kind of intimidating, but. You have been fired. That.
And chased by animals. I don't get out until I'm warned. We'll give you guys a moment. I know, Judge, you guys usually go through the paperwork and check everything.
Yes, yes, yeah, we'll go through the paperwork, thank you.
You're welcome.
Okay, now, ladies and gentlemen, the paperwork that you have, we're gonna go through that paperwork, make sure that it's filled out properly. If you need any help with filling out the paperwork, we have our court personnel, including myself, who will, go over the paperwork, which, now, what we're gonna do, we're gonna call you up, and we're gonna put you in, we're gonna call you at one at a time to come before the bench. But before that, we're going to put you into one of three categories. One category is you wanna hire your own attorney. And if you wanna hire your attorney, your case will be reset today. You'll be given another court date, to give you time to hire your attorney. Number two, if you would like to apply for a court-appointed attorney. If you qualify, your attorney will be appointed today before you leave. And number three, if you would like to waive your right to an attorney and represent yourself, if you're able to work out a plea bargaining agreement with the state, your case will be taken care of today. Okay? Now, as I mentioned to you earlier, we will pick up that paperwork. It's gonna take us a little time, a few minutes to go through the paperwork. And, if you need to use the restroom, there are two restrooms right outside in the hall. The men's restroom is in front of county court at law number 3. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, you'll be allowed to use the restrooms. After you use the restroom, please come back in the courtroom. Do not leave the courthouse. If you leave the courthouse and your name is called and you're not here, then your bond will be forfeited. A warrant will be issued for your arrest. You will be arrested, placed in the county jail. You'll probably get out on bond, and guess what? We're gonna have to go through this all over again. So we don't want to do that again. So just make sure that you come back into the courtroom. Oh, I forgot to mention this too. On the paperwork that's on the clipboard, you're gonna see at the top, it says State of Texas versus, and there's a blank line. Print your name on that line. And the reason why I said print is because if your handwriting is like mine, sometimes I can't read. Okay? So just print it so we have an idea of who you are. Okay, so when we call you there, because sometimes I'm on there like, man, what is this trying to, nobody can figure it out. Okay. And so, make sure that you print your name, all right? We're going to, get started. No, first of all, if I do that, we have any questions before we go any further? Okay, no questions. We're gonna go into recess. And again, be mindful that we're in the courtroom. So conduct yourself accordingly. All right. Right in the front. Yeah, I'm not on the side.
Yeah, I'm not. Martin. I might bring it in a little bit. But it's-
You have it. Okay, this is cause number 26CCCR 0924, case is style the state of Texas versus Adam Paul Reynolds Avalos. Mr. Avalos, is that your full name? That's not Avalos? Who is Avalos? Him? Okay. What's,
I did working.
oh, is this, oh, this is one, hold on. We hadn't, I'm. Court is in session and calls number 26CCCR 0948, case is style the state of Texas versus Timothy R. Hartfield, but you say your name is Timothy R. Hatfield. Is that correct? Okay, Mr. Hatfield, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand down. How are you doing? You all right? That's good. Now, Mr. Hatfield, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? You recognize this document? Could you show him?
I just gave you that sign.
Okay, and is this your signature on the line that's titled defendant?
Yes.
Are these your initials on the line that state you like to apply for court appointed attorney? I also have another document that is titled that's titled Jefferson County Affidavit of Interest. Do you recognize this document? On page 2 of this same document, there's a signature on the line that's titled defendant. Is this your signature? Now, Mr. Hatfield, before you signed and initialed these documents, did you read the documents? Do you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Hatfield, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you. And you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to follow the bailiff and you have a blessed day. Okay, you can follow the bailiff. Yes, I just did.
We put nothing in the back. Should we take a few more copies? There's no hard time. No, I'm taking.
Yeah, you can bring.
that.
Yeah,
That's about.
yes. I'm a-
Say no?
Well, I'm gonna call him up.
Oh.
Have him. Give me the paperwork. What?
Here.
Ricky Renard Zeno? Need to give him some bond conditions.
He has an accompanied felony judge, Martian Holmes on the case.
Okay, you heard that?
F
He has a felony.
260353.
Yeah, what?
He has a felony, another felony.
I didn't see the date.
What's that number, Carney?
F 26-0353. It arose out the same set of factors.
It's what?
I'm sorry. -0353. Checking just see if it's still in received status.
Okay, why don't you make a copy of that for me? Okay,
Apology, Judge. It was created on February 10th. It rose the same date. It's just showing received status. So this is.
Okay, that's fine.
As well. This is-
let's see, this is, Jackson. This is. I need a copy of these two. Okay. Jefferson County Court of Law number 2 is back in session. And clause number 26 CCCR 0980 case of style of state of Texas versus Ricky Zeno. Mr. Zeno, is that your full name? Mr. Zeno, would you have gum in your mouth? Okay, Mr. Zeno, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Zeno? That's good. Now, Mr. Zeno, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you like to have your case reset to hire your own attorney? Okay. Now, Mr. Zeno, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Zeno, I read your answers. Your case will be reset, but before your case is reset, Ms. Bailey, would you please hand this document to Mr. Zeno? Mr. Zeno, the document that's just been handed to you is titled Standard Bond Conditions in County Court at Law number 2. And it states, following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? You have to speak up.
Yes, sir.
Okay, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3 and 4, does not apply. However, on the next page, condition number 5 does apply, and it states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that conditions? Now, Mr. Zeno, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, Mr. Zeno, you're gonna have a seat in that first, it's just, you can get your reset. Once you get your reset, you're free to go, and you have a blessed day.
You good? No.
David Garcia. Mr. Garcia, your full name is David Garcia?
Yes, sir.
Okay, Mr. Garcia, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Garcia, you may put your hand down. How are you doing, Mr. Garcia?
Pretty good.
That's good, Mr. Garcia. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes.
Or are these your initials on the line that states you'd like to have your case reset to hire your own
Yes.
attorney? Before you signed and initial this document, did you read the document?
Yes,
Did you understand what you read?
yes,
And is everything in this document true and correct
yes.
to the best of your knowledge? Okay, Mr. Garcia, your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator will reset your case. You can get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day. Let's see, Mr. Ethan Rodney LeMay is on Zoom. Mr. LeMay, how are you doing?
I'm all right, sir. How are you?
I'm doing fine. Thanks for asking. Now, Mr. LeMay, you set through the arraignment. Your case will be reset to June 23rd, 2026. You need to be here in court in person. Stay in contact with, it's June 23rd at 9 a.m. in County Court at Law Number 2 of Jefferson County, Texas. You need to be in court in person. Stay in contact with your bondsman. You're free to go, and you have a blessed day.
Yes, sir. Thank you.
You're welcome. Is Elijah Godfrey? Elijah? Okay. Ms. Godfrey, your full name is Elijah Godfrey. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may put your hand down. How are you doing, Ms. Godfrey? I'm doing fine. Thanks for asking, Ms. Godfrey. I have before me a document, well, two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And she didn't sign it. Didn't sign it. You're supposed to sign and date it.
Right, Look at my pen.
Yeah.
Oh, look at my pen.
It's on there, just like, it's on there. Had you ever, hold on, you, nothing? Nothing, you can do it with this. Zero, fine, bring it. Jefferson, even Blaze, they agree. What is the list here? I mean, okay, so. What's that, today's date.
Put June night right here, or I should put this back.
No, no matter, it don't matter, okay. In the year.
You're gonna get us to Mr. Avalos, he has to do the same thing. He's in the back. Okay, now Ms. Godfrey. On judge's explanation of rights to defendants without attorney, you recognize this document? Is this your signature on the line that's titled defendant? Are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled, Jefferson County Affidavit of Indigence. You recognize this document? On page two of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
Ms. Godfrey, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Godfrey, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that would be appointed to represent you in this case is Attorney Jennifer DeLage. Attorney DeLage will be given information on how to contact you, and you will be given information on how to contact her. Our court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. Adam Reynolds Avalos.
This is your card.
Okay, is your full name Adam Paul Reynolds Avalos?
I would,
Hmm?
I would,
What is,
Adam, I would, with R.
you say Raul? Oh, that says Paul.
Yeah, no, big shit.
It's supposed to be, it has Adam Paul Reynolds Avalos, but it's Adam Raul Reynolds Avalos. Find out what's going on in the back. Charles Marshall. Mr. Marshall, let's see. Your full name is Charles Christopher Marshall. Ms. Marshall, would you please raise your right hand? Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Marshall, you may put your hand down. How are you doing, Mr. Marshall? I'm doing fine, thanks for asking. Mr. Marshall, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Yes. Are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature? Okay, Mr. Marshall, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Marshall, I read your answers. Based on your answers, you meet the eligibility requirements of court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information, you're free to go,
Yes, sir.
and you have a blessed day.
Thank you.
He's gonna have a seat. Just have a seat in that first chair on the wall. Lakeisha Victoria. Okay, Miss Victoria, your full name is Makisha Anquinette Victoria?
Yes, sir.
Miss Victoria, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Miss Victoria, you may put your hand down. How are you doing, Miss Victoria?
Fine.
That's good, Miss Victoria. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Victoria, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Victoria, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Mark Fager. Attorney Fager will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. Please have a seat in the second chair on the wall. Next case is Tiffany Jackson. Okay, we have two cases. There are cause numbers 26CCCR 0836 and cause number 26CCCR 0838. Both cases are styled the state of Texas versus Tiffany Jackson. And Ms. Jackson, is that your full name?
Yes.
Ms. Jackson, would you please raise your right hand? Ms. Jackson, your other hand, ma'am.
I read.
Okay, Ms. Jackson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Jackson, you may put your hand down. How are you doing, Ms. Jackson?
All right.
That's good. Ms. Jackson, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? Yep.
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Now, Ms. Jackson, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
Is everything in these documents true and correct
Yes.
to the best of your knowledge? Now, Ms. Jackson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in these cases are Christy Carlton. Attorney Carlton will be given permission to contact you, and you will be given permission to contact her. Our court coordinator will give you that
Jack,
information.
Have you had a chance to read the PC in this case of think additional conditions? After we said in that?
I got some.
Okay, I'm sorry, Jack.
Now, Ms. Jackson,
Yes.
before you take a seat, I need to give you some bond conditions.
Mhm.
The bailiff is gonna hand you a document that's titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over these bond conditions with you. And it states, following return of accrued information in County Court at Law Number 2 of Jefferson County, Texas, all bill bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Mhm.
You understand that?
Yes, sir.
Okay. Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3, defendant shall not communicate, either directly or indirectly, with the alleged victim or victims of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victims in each case. Do you understand that?
Mhm.
It's a no contact. Now, condition number 4 does not apply, however, condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? And condition number 7 states that the defendant shall wear a global positioning monitoring system device at the defendant's expense with written verification being submitted to the court within 3 days. Do you understand that condition?
No, I don't. What that mean?
That means you're gonna have to get an ankle monitor. Okay?
And
That's
what this ankle monitor is?
Now, hold on, first of all, Miss Jackson, you need to change your body language.
Yeah, but I need to understand.
Okay, I'm getting you to understand, you're gonna have to wear ankle monitor,
Mhm.
okay?
Yeah, what is that?
It's an ankle, it's a device that they're gonna put on your ankle, and we'll know your movements, places that you can and cannot go to, you'll be monitored. Okay,
And how long I gotta wear this ankle monitor?
this might get, as long as you're on bond.
So if I go back to jail and sit it out, I don't have to wear it.
Well, it's true.
Victoria. Want to know my options?
Okay, but
Yes.
you can talk to your attorney about that. And your attorney is Christy Carlton.
Okay.
All right?
Mhm.
All right, and our court coordinator is gonna give you a reset, and she's also gonna give you information where you can get that global positioning device from. All right?
Mhm.
All right, just please stand over there.
Yes, ma'am.
Here you go. Next This is cause number 25 CCCR 2366. Case is style the state of Texas versus Amanda Renee Shelton. And Ms. Shelton, is that your full name?
Yes, sir.
Ms. Shelton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Okay,
Looks like behind me the way you were looking at.
but you go get her, tell her to come back. Okay, this is cause number, again, 25 CCCR 2366. Case of style the state of Texas versus Amanda Renee Shelton. And Ms. Shelton, you're represented in your case by your attorney Lori Perazzo. And Ms. Perazzo, how are you doing?
I'm doing well, Your Honor. Thank
And
you.
Ms. Perazzo, do you waive a record in Ms. Shelton's case?
Yes, sir.
Ms. Shelton, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Amanda Renee Shelton, on or about August 24th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Ms. Shelton, do you understand what you have been charged with?
I do.
To this charge, how do you plead? Guilty, not guilty, no contest.
No problem.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Shelton, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, I do.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked, no continuing, which means no contest. You place your initials on this
I
document.
did.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, I do.
And is this your signature on the line that's titled Defendant?
Yes, I do.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have another document that is titled Discovery Certification. Do you recognize this document?
I do.
And is this your signature on the line that's titled Defendant? Now, Ms. Shelton, before you signed and initialed all these documents, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge?
I do.
Ms. Shelton, are you a citizen of the United States?
I am.
Stacy talked to this honorable court, Stacy exhibit number 1.
Any objections? No objections. State's exhibit number 1 will be admitted. And Ms. Perazzo, you have advised and counseled Ms. Shelton. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
And Ms. Shelton, your attorney, Ms. Perazzo, has advised and counseled you. Are you satisfied with her representation?
I am.
Ms. Shelton, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what's the agreement?
The essential terms are as follows, Your Honor. It would be 240 days in a county jail. However, they'll be probated for a 20-month period of time. I'm sorry, 24-month period of time. There'd be $100 fine, $6 community service, and $1,500 restitution to Santana Fuentes, as long as no contact with Santana Fuentes. Is that correct, Ms. Perazzo?
That is correct. Mr. Bowman.
You want to get her? She need to-
Hey,
Here you are.
Thank you very much.
Gotta get together.
Okay, now, let's see, that's, Ms. Peraza, were you appointed in this case?
Yes, sir.
The court, what's the court cost? 337. And let's see, it's 24 months. Okay, Ms. Shelton, the state is offering that you serve 240 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 24 months. During the 24-month probationary period, you'll be required to pay a fine of $100. Oops, I forgot to put, is that $1,500 restitution?
Yes, Judge.
Oh, I forgot to put that in there. Okay, Ms. Shelton, the state is offering that you serve 240 days in Jefferson County Jail. However, you'll not be required to serve any time in the Jefferson County Jail because you'll be on probation for a period of 24 months. During the 24-month probationary period, you'll be required to pay a fine of $100 plus court costs of $337. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to reimburse Jefferson County Code Appointment attorney's fees of $350, and you'll be required to pay restitution, bless you, in the amount of $1,500 to Santana Fuentes. The total monthly installments, that is the total amount that you will be required to pay each month, is $178 a month. Are you able to pay the $178 a month? Okay, you'll also be required to perform 60 hours of community service. You cannot have any contact with the victim, in this case, Santana Fuentes, and you'll be required to adhere to the other standard terms and conditions of probation. Ms. Shelton, do you understand the state's offer? And do you accept the state's offer? Ms. Shelton, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Shelton, you'll stand next to the bailiff, follow her direction. Once you finish following her directions, you'll be free to go, and you have a blessed day. Okay. Yeah, Denise. Who's this? Is that her?
Okay, what's on? You want to be ready for up there?
No, hold
No,
on, wait,
no,
hold
no.
on. I thought, what's this lady name in the back?
Miss Desiree,
That's Larry.
this Desiree Barnes.
You know, there are certain breathing techniques that you can use to calm you down. And one of them is stop, taking a deep breath, inhale, exhale. Inhale, exhale. But guess what? It doesn't work unless you use it.
Yes.
Okay. Now, there are other things that you gotta understand that you're saying you're trying to work on your anger. Okay. Okay. Well, that's good. But you're gonna have to do what you're required to do. Okay. We have rules in this court.
Yes.
Actually, there are rules in every court.
Yes.
And as I mentioned to you, I didn't mention to you earlier. But if you violate these rules, you could be held in contempt of court.
Yes.
Now, I know you said that as it relates to the ankle monitor, you mentioned something about if you go to jail or whatever, would you have to do the ankle monitor? The point I'm trying to make is this here. you'll be expediting yourself going to jail for contempt of court, because the court can hold you in contempt of court if you do not follow the rules. Okay? One of the rules, you can't cuss in court. Okay? Leaving out of court, you can't cuss. But you need to conduct yourself, you need to take control of your anger. Okay? Because if you don't do it, you're not gonna be sitting in county court, you might be sitting in front of district court.
Yes, sir.
Okay, and you're sitting in district court, you ain't gonna be looking at going to county jail. You're gonna be looking at going to the penitentiary. Okay? So you just need to calm down. You have a lawyer. Stay in contact with your lawyer. Why don't you get her some wipe her tears?
Right here, in front.
Okay. You can wipe your tears, ma'am.
Yeah, it's just the fact that it's whole situation.
I understand, but what I'm just saying, just calm down. Okay? Okay, just calm down. You're making it worse with your behavior. Okay, you go from 0 to 100. Okay? You control that. Okay? I just have the obligations to, based on your behavior, to do what I need to do.
Yes, sir.
Okay? And so you need to calm down. Okay? Hold on, let me do this here before you go any further. Now, at this time, again, your case is going to be reset, and you need to make sure that you conduct yourself accordingly. Okay? You have any children?
Yes.
Okay? And you say you're employed. Okay? You can get some more tissue
Yeah.
if you desire. Okay? So just you gotta be positive. Okay, you going, you thinking the worst. Just think about it. Somebody went to bed last night and didn't wake up. But guess what? You woke up.
Yes, sir.
Okay? You got somebody laying under a bridge, but you got a roof over your head. Right?
Yes, sir.
There are a lot of things you could be thankful for. Okay, so don't just focus on this. Focus on other things. Okay? And just, put it in his hands.
Yes, sir.
All right?
Yes, sir.
All right. You're free to go.
Check out this.
Huh?
Sign those.
Oh. You can stand in front of that. Okay, Mr. Eustace, your full name, well, your full name is Denise Eustace?
Mhm.
Ms. Eustace, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. You may put your hand down. How are you doing?
So.
So? Okay,
Could be better, could be worse, you know?
okay. Now, Ms. Eustace, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir. Correct.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are a set of initials that's titled, that's on a line next to a box that states you like to apply for court-appointed
Yes, sir,
attorney.
please.
Next document is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir, correct.
And is this your signature on page 2 above the line that's titled Defendant Signature?
Yes, sir, it is.
Now, Ms. Eustace, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Eustace, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Mason. Attorney Mason will be given permission to contact you, and you will be given permission to contact him.
Okay, correct.
Our court coordinator will give you that information. Once she gives you that information, you'll be free to leave, and you have a blessed day. And just by the way, Mr. Mason gonna be here in court this afternoon, probably at about 1:45.
Okay.
I don't know if you want to meet him, but if not, you can call his office after 24 hours, and he'll be in contact with you as well.
Okay, yes, sir.
All right. You can stand in front of the bailiff.
Okay.
You'll be free to go, and you'll have a blessed day and keep that same attitude.
Oh, yeah, every day.
All right.
Your phone number is 409. That
Court will be in recess till 1:45 to resume with the trial.